Lesson 1. Introduction to Alternative Dispute Resolution, ADR. 1.1. What is alternative dispute resolution? There are two ways to resolve disputes. 1. Through the courts, litigation, and 2. Outside the courts. Alternative dispute resolution, ADR, refers to various methods by which parties in dispute can resolve their conflicts outside the court trial system, which in the past was relied upon entirely. ADR offers separate non-judicial forms and procedures for dispute resolution. Conflict and dispute are inevitable parts of life. Disputes arise whenever they occur between family members, neighbors, business partners, or nations. Over time, societies have developed a variety of ways of resolving disputes. This lesson examines some of the different ways to resolve legal disputes, with a focus on commercial disputes. There are at least 4 ways to settle a legal dispute: negotiation, mediation or conciliation, arbitration, and adjudication. Adjudication is the use of the court system to resolve disputes. The other 3 options are the main types of alternative dispute resolution, ADR, which refers to methods of settling disputes outside the court system. The methods of legal dispute resolution may be said to lie along a kind of continuum, with the authority of the neutral growing as one moves along the continuum. In negotiation, there is no neutral. Only the parties participate in the process of trying to resolve their dispute. In most forms of mediation, which may also be called conciliation, the neutral meets with the parties and enforces basic rules, offers opinions about the strength of each side's argument, and proposes possible solutions. In arbitration, the neutral enforces basic rules and may offer opinions and solutions, but he goes farther than in the previous methods and actually makes a decision about the dispute. If the parties choose binding arbitration, they must accept the results, which can generally be enforced in court. In adjudication, a court judge enforces basic rules, may offer opinions and solutions, and makes a decision that is binding on the parties. Illustration: Role of neutral in dispute resolution methods. Negotiation. None. Parties try to resolve dispute by themselves. Mediation or conciliation. Enforces basic rules, offers opinions, and proposes solutions. E.g., let's talk about your dispute and try to find a good solution. Arbitration. Enforces basic rules, may offer opinions and solutions, and makes decisions that, if the parties have previously agreed, bind the parties. E.g., tell me about your dispute using the rules you have chosen, and I will make a decision that may bind you. Adjudication. Enforces basic rules, may offer opinions and solutions, and makes a decision that binds the parties. E.g., tell me about your dispute using the legal rules that apply, and I will make a decision that you must follow. Why are these methods of legal dispute resolution sometimes called alternative? The reason is that in some places, the courts have traditionally been the forum people have used to resolve legal disputes, especially commercial disputes. In recent decades, however, many people, particularly in business, have realized that there can be serious drawbacks to adjudication. Adjudication is often considered to be more expensive, time-consuming, and emotionally difficult than ADR. So people have begun trying alternatives. Of course, in some other communities, these alternative ways of resolving disputes have traditionally been the preferred ways. The initial decision to use ADR is voluntary. In contract disputes, the parties have already agreed to use ADR in a clause in their original contract. In other cases, the parties adopt ADR after a dispute has arisen when they make a special contract to do so. Many international arbitration centers require that parties who wish to use their services sign a contract agreeing to arbitrate. The parties may decide informally to try a form of ADR instead of going to court. If the party has not agreed to use ADR, then ADR is not possible. In fact, agreements to use ADR are usually contained in a contract. Where parties have agreed to ADR contractually, they are legally bound to use it, just as if they had signed a contract to sell goods. If they do not perform according to their contract and have no legal excuse, a court will enforce the contract and its ADR clause. This is especially useful where the parties have agreed to binding arbitration. The reason is that a court can order the party who is resisting arbitration to go through the process until the arbitrator makes an award. But of course, there are limits to what a court can order. A court can enforce a contract requiring the parties to try negotiation or mediation, but the court cannot compel parties to actually reach an agreement using those methods. ADR is used in civil disputes. ADR neutrals are not used in criminal cases. Crimes affect basic interests of an entire society and require strict enforcement methods. Of course, a criminal defendant can sometimes negotiate with the prosecution to resolve court proceedings against him. But even where there is such a resolution, the court generally still imposes some criminal penalty on the defendant. ADR outside off the courts is probably not sufficient to resolve criminal problems fully. ADR neutrals lack the power to impose criminal penalties. ADR systems have no practical way to restrain those criminal defendants who may present threats to public safety. Legal disputes may have both civil and criminal elements. For example, battery and certain other torts, non-contractual civil wrongs, may also be crimes. An ADR neutral could potentially help parties resolve a civil dispute based on such a tort, but could not participate in a related criminal case. Although ADR typically occurs without government involvement, in some jurisdictions, government does play a role in the provision of certain ADR services. For example, in the United States, the Federal Mediation and Conciliation Service helps to resolve some important contract disputes between organized labor and management, and also conducts training for unions and management in order to improve cooperation. However, where governments do become involved in ADR, it is essential that they remain completely impartial. Moreover, in some places, other methods of legal dispute resolution have developed, particularly hybrid forms that combine elements of more than one of the forms discussed above. For instance, in some jurisdictions, parties may use dispute resolution methods that combine elements of adjudication and arbitration. However, because many of these other methods of dispute resolution are still fairly new, and their features may not be completely clear, this text will focus primarily on the basic forms introduced above.